X surreptitiously hauled detergent cases from ABC supermarket to its open parking area where Y waited. X returned inside, came out with more detergent cases, and unloaded them in the same spot. Thereafter, X and Y hailed a taxi and loaded the detergent cases into the vehicle. The security guard who had been observing their peculiar behavior stopped the taxi and asked X and Y for a receipt for the merchandise. However, X and Y alighted the taxi and ran away. But before they could leave the premises of ABC supermarket, they got arrested. Taking into consideration that X and Y did not have the opportunity to dispose of the goods, the prosecution charged them only with frustrated theft. Is the charge correct? Reasons. No, the charge of frustrated theft is not correct. The proper charge is consummated theft. Under Article 308 of the Revised Penal Code, RPC, theft is committed by taking personal property of another without consent and with intent to gain. Jurisprudence has consistently held that theft is consummated once the offender obtains possession of the property, even if he has no opportunity to dispose of it. In Valenzuela v. People, GR number 160188, June 21, 2007, the Supreme Court categorically abandoned the intent to dispose rule and clarified that theft has no frustrated stage. Once the property is taken and brought under the control of the offender, the crime is consummated. The offender's ability, or inability, to freely dispose of the property is immaterial. In this case, X already removed the detergent cases from the supermarket shelves, carried them to the parking area, and loaded them into a taxi with the help of Y. At that point, they had already acquired material possession and control over the stolen goods. Thus, theft was consummated, regardless of the fact that they were apprehended before they could flee with the items. Therefore, X and Y should be charged with consummated theft, not frustrated theft, since theft does not admit of a frustrated stage.